Hey guys, welcome to today's video. Today we have an update on a sovereign citizen known as Old Squishy Gardner Codlin, someone we have been following for quite some time, so let's get into it.
I think you've been in front of me twice, and I think you were in front of Judge Ransom last time. I know your position regarding the authority of the court. To keep matters moving, though, I have to set a time limit as to how long I'm going to allow you to address the court. Hold that thought. I know you always have a concern, and rightly so, as to whether or not we're on the record. My concern is from where you're standing, I'm not sure the microphones are able to pick you up well enough to get an accurate record, and the court reporter is telling me that. So what I'm willing to do for purposes of this case is I'm going to put on notice that allowing you to pass behind the bar and enter into the well, I'm not agreeing to take jurisdiction over you. I'm allowing you to come forward so that you can make the appropriate record that you wish. Because my concern is, even if you project your voice, sometimes the microphones are just these little triangular things on the table. So my concern is they're not going to pick you up. So I would prefer that you come in and sit next to counsel's table. I don't exercise jurisdiction over you by doing that if you choose to come forward.
All right, so thank you.
All right. If you can come up and have a seat next to Mr. Hartel. So, Mr. Leffers, we're already past noon.
Sir.
So what I'm willing to do is, do you think you can state what you want to state within will 5 minutes be enough time?
I'll do my best.
All right. So I show we're at about, well, I'll give you, my desktop says 12:05. It looks like the wall clocks say 12:06. And it looks like they're synced up with each other, so go ahead.
No disrespect intended. Are we on the public record, sir?
We are.
And as redundant as it might be, just please continue to be honorable. Your Honor, I am Phil Levers, lawful representative of the estate in question. I want it on the record. Y'all don't have jurisdiction. I voluntarily appear in this court today on special appearance.
So you're making a special appearance. Is that why you're wearing your special overalls today? And I'm sorry, but if the court doesn't have jurisdiction over you, then what exactly are you doing there, other than making a fool of yourself?
I move the court to take judicial notice of the Michigan Constitution as ratified without subsequent amendments in the U.S. Constitution and your oath to them, Your Honor. What say you?
Well, as I said before, I acknowledge I took an oath to uphold the constitutions.
Thank you, sir. Moving forward, Article 3, Section 2, Clause 2 clearly states that when a state is a party to the case involving a citizen of that state, the Supreme Court has original jurisdiction, which makes these proceedings improper, violate the Constitution. It's the wrong venue. The request that I've supplied, which I have to amend, because now there are extra things added, and Mr. Champion also and RJ at the defender's office refused to allow us evidence. So I'm still being denied due process. Your Honor, for the record, I am making a clear and unequivocal demand to represent myself in this matter. I am invoking my Sixth Amendment right, as recognized by the United States Supreme Court of Ferretta versus California, 422 U.S. 806, 1975. And we have read up on the Wiggins. What? McClaskill, that's right. The McClaskill and Wiggins and implied change in law. I do not accept standby counsel, which affirms my right to proceed without counsel when the waiver is made knowingly and intelligently. I respectfully decline any court-appointed attorney. You all are friends. Y'all know each other. You most recently took this seat, sir. I made friends with a lot of my coworkers in the past. I'm not going to get a fair trial here. Due process is being denied on that as well. I understand the nature of the charges against me, the penalty, and the risk involved in self-representation. I am making this decision knowingly, intelligently, and voluntarily. I ask the court to conduct any required inquiry to establish that my waiver of counsel is valid and to allow me to proceed pro se. Your Honor, I am making a clear and unequivocal demand to proceed pro se under Ferretta. I am not asking for different counsel. I am waiving counsel entirely. They are impeding upon my due process. Jawkins didn't give me anything that I asked for. In fact, he got upset at me, cussed at me, told me to mind my own business, look over this. Jurisdiction is broken. Due process is broken. I'm not being treated fairly. That is my stance. If you want to indict me on a grand jury trial, please do so. Otherwise, this needs to be dismissed with prejudice or full exoneration, or pull the trigger. Let me go up there. I'll talk to them. It's been a pleasure meeting you.
Well, it's been a pleasure meeting you too. When you say go up and talk to them, who do you mean?
Supreme Court.
Okay, all right.
On a federal indictment, which as a national, we're in different jurisdictions, sir.
So you've decided to make a special appearance. Is that why you've got your special overalls on today? And I'm sorry, but if you really believe the court has no jurisdiction over you, then what exactly are you doing there besides embarrassing yourself?
I have a couple questions in that regard. So first of all, by representing yourself, do you believe that you can conform to the rules of the court, the published court rules?
With that, finding out other things. Most recently about my hometown, the past 2 judges have been removed by the tenure council. So canon 1 through 5, indeed, it also expresses that you're the guardian. Prosecutor is the guardian. Lawyers are guardians of our liberties and the constitutional right. So when someone pro se makes a mistake, and even un-pro se, the prosecutor is supposed to be there to uphold justice, not pervert it. And that's what this is about. So canon 1 through 5, if I make a mistake, please correct me. If I file something wrong, the clerk has let me and my wife know, okay, well, this isn't how we do this. We can accept an amendment, you write it in, blah, blah, blah. Okay. So I will do the best I can. I am very different since dying, coma, botched surgeries. I'm a permanent head trauma case. My short-term memory is gone. So unless I build a consecutive day after day, that same time, every time, I'm not going to remember. And Einstein said, it is worthless to waste brain power on things that you can write down.
So, so as the independent party here, and just so you know, I don't know how, I'm guessing you've probably done some checking into me, but I don't know. Before I was the judge, I was the prosecutor. Before I was the prosecutor, I was a public defender. So I've played roles in all 3 parts here. So I
watched your videos while you were a judge. I watched the one of the 2 gentlemen that were arrested, and you released them. You dismissed their case. They were arrested over off of 13th or something over by a body shop, running meth. But the officers, same 2 officers that are involved in my case, tandem, like they do most of the times, which is why they were so close together on my case. They had to realize that they had to be closer together after you threw that case out. They broke the Constitution. I watched what you did, and I watched 2 other videos, which they fully got what they deserved. They broke the law unequivocally. But those 2 gentlemen, yes, had the Constitution not been broken, you would have been just fine with proceeding forward with not dismissing their case. But on the grounds that the first thing that the officers did, they broke the law, and then they broke the Constitution, which is exactly what's going on here. My wife and I have been involved in several auto accidents where the Cadillac Police Department refused to fill out a police report. There's not $1,000 worth of damages. The lady dragged her vehicle all the way down the whole side of our truck, from the bumper to the front quarter panel. The captain of the Cadillac Police Department and 5 others were there, and they wouldn't write a ticket. So these 2 officers and other officers state, well, we don't have to do anything on private property. Well, this whole thing was on private property.
I hate to break it to you, but the Supreme Court of the United States only hears about 60 to 80 cases per year. So I don't think they're going to make it a priority to take up the case of McDump and his wife.
Officer stated that he had probable cause because he observed me driving. That's a lie. Jurisdiction, lies. You're an honorable man from what I've seen.
So where I was going with that is that, yes, I can provide you leniency, but I can't do it in such a way that it's detrimental to the other side.
Correct.
My side, I'm kind of like an umpire. I call balls and strikes, so to speak.
Correct.
So while, yes, I can give you leniency, I can't spoon feed you things as to what to say, what to file, that sort of thing. So I guess my next question is if I do allow you to represent yourself, would you be willing to have an attorney somewhat of counsel where they wouldn't necessarily be the attorney of record, but you would be able to talk to them about, proper, how to properly file something, how to, if you have any legal questions, how to, interpretation of the court rules, that type of thing. Is that something that you would be open to? So you would be representing yourself. You would just be able to rely on them as a reference.
The problem with that, sir, with all due respect, my wife and I asked Jockins for the supposed 14-second video of not our truck. Whether those are the victims or not, that wasn't my truck. In that 14-second video, that wasn't my truck. Now, I do not accept the fact that I had to watch it at the defender's office, and I still have been refused because policy and procedure, because others have put this stuff out on public notice. My wife has had her video of her accident because she had to take up the reins and take care of herself through her job. Nobody knows about that video. Nobody's seen that video. And most recently, we found out a bunch of other things. There's a conflict of interest. And the prosecution didn't say anything. My wife, who was ran over and her legs are destroyed, was made a victim. She's being made a victim again.
That's in this case?
Yes, sir.
All right.
She was removed as victim and placed as a witness.
So let me ask you, and I understand why we're getting a little heated, but
sorry.
Hold on, let me get my question out. So when you say you haven't been provided discovery, do you mean that it hasn't been physically handed to you, but you've had the opportunity to at least watch it?
Discovery, as I'm learning, is a multiplicity of things. And they have specific names.
So let me be more frank, because again, I'm on a time clock here.
Correct.
So let me just ask you, have you seen the video? Not has it been provided to you, but have you seen at least what they're saying is the video?
No.
Okay. Have you seen the police report?
The defender's office, while playing it, it stopped. There's an error. And the video was never allowed to be loaded back up and seen past a specific point, and it crashes every single time.
But they at least
RJ stated, he's like, I just watched all of these. I don't understand what's going on.
But they at least attempted to play it for you, and then it crashed.
I wasn't.
Presumably.
Discovery means that the Evidence goes to me.
No,
I
understand, but just
look over it.
focus on my question for a minute. My question is, were you given the opportunity to at least try to watch the video? I understand there were some technical issues, but did you at least,
Yes.
you were given that opportunity?
Yes.
And were you given the opportunity to review a police report? Maybe not handed, but did you at least, and don't talk about what they told you because I don't want to get into attorney-client privilege, but did you at least have the opportunity to generally say, okay, this is what the police report says, what do you say, and then kind of merge the two?
Object. The insinuation of attorney-client privilege against our police.
Well, I had to be careful of that because I had appointed counsel.
Correct.
So I'm setting that aside right now. So at least by the time that you had counsel appointed, that's what I'm considering attorney-client privilege.
All right.
Not from here forward, just during that time period that you were with either Mr. Jockins or you were with Mr. Champion.
Yes.
Did you at least have the opportunity to go through a police report? Maybe not being handed to it or handed it.
We're given the addition to the police report. We were given the police report originally by Mr. Jockins.
Okay.
Which at the bottom of the police report, and there's no signature of any witness. It was Officer Dot, right?
All right, Mr. Leffers, I need you to focus on me because this is one of the rules of the court.
Yes.
It's not appropriate for you to be interacting with.
This is a criminal case and it has nothing to do with a trust or equity. And since you brought up the Constitution, you might want to take a closer look at the 10th Amendment, which leaves police powers and most criminal jurisdiction to the states.
Violated. I don't have a problem with that.
All right.
That's what I'm saying. Now,
So if I allow you to represent yourself, are you going to be able, again, to comport yourself? Because realize that in the grand scheme of things, right, the Supreme Court's up here. I'm the district court. I'm way down here. There's lots of courts to get through before you get to the Supreme Court for appellate purposes. So a lot of the things that I'm left to decide are necessarily what the law says, what the Constitution says. The Constitution that is currently before me, there isn't, the appellate courts would have to tell me I'm wrong. Do you understand that?
sir, but we could read the Constitution.
No, I understand that, but what I'm saying,
Article 3, Section 2.
but what I'm saying is, because I've also noticed that in some pleadings, you said that you're not a 14th Amendment citizen, but hold on, but yet in the last pleading, you said I was violating your 14th Amendment.
It's a compilation of books.
Well, but
sir.
see, it can't be. So,
But it is,
but see, that's where things kind of go off the rails, because you would agree with me, right? That if you are not a citizen of the United States, let's say you go to Japan, for example, all right? Are you not then subject to Japanese law if you're on their land? Whether or not you're a citizen, you would still be subject to Japanese law, correct? No, it's not an analysis. It's you still retain your U.S. rights and citizenship, but the minute you would step into that territory of Japan, you're then subject to their laws.
Anything that abrogates the Constitution and its amendments is unlawful.
But the Constitution doesn't apply in Japan, right?
Well, it does. Because what national are you? That's also protected internationally, to the international.
It's cute. You're not getting your way, so you're trying to frame it as an inability to be impartial issue, when in reality it's just a refusal to follow the laws of the city, county, and state you're standing in.
I will allow you to represent yourself, but I'm just forewarning you that you are going to be held to the same standards and procedures, whether or not you agree with those standards and procedures, because that is what I'm bound by. The standards and procedures that have been set by the Supreme Court, the laws of the state of Michigan. And when I say the Supreme Court, I mean both the Michigan Supreme Court and the United States Supreme Court. The laws of the state of Michigan and to the interpretations and case law of the when it comes in regards to interpretations of the U.S. Constitution and the Michigan Constitution. Now, I realize that you because you've cited the 1850 Michigan Constitution, in this court's eyes, I believe it's the 1963 is the date. Don't hold me to that exact date, but the latest version of the Constitution. When citizens are able to pick and choose which things they agree with in the Constitution and which things they don't agree with the Constitution, that's where things run afoul. And that's where it takes a court a lot higher than me to make that decision. So it's a long-winded way of saying is I am only going to be bound by what is appropriate for this court. If you need to take it to higher courts, that's certainly your prerogative. But moving forward, can you at least agree to that?
Okay, so from what I remember is that the judge or the prosecutor, depending on how they file it, in which the prosecution filed it incorrectly, especially after finding out about my nationality status. Nationality status is protected by the Constitution, and the Supreme Court has ruled on that several times over. Now, the prosecuting office is supposed to refile the paperwork then and go for a grand jury indictment.
So there's a proper procedure in which you have to go through to do that, and this is not that proper procedure.
And if the prosecutor doesn't want to do that, then it falls upon you to make the decision. Where the truth is what it is. And Ezekiel 3:18-9. If we are seeing someone in sin and we don't say something, on the day of judgment, whatever you have seen, for anyone you didn't say something to, you will be judged for it. So, sir, I respect you and your honorable ways that I've seen. The Constitution and my rights are being broken and trampled on. My due process is broken. I cannot get an impartial.
Who else isn't surprised he's from Alabama? I'm pretty sure his sister, cousin, and wife aren't shocked either. At this point it feels like the family tree doesn't really branch out, more like a straight line that loops back on itself. And somehow he still acts surprised when things don't go his way. You really can't make this stuff up.
What'll happen is if I allow you to represent yourself, you would then be able to file the demands for discovery, and the prosecutor would have to turn over to you what they have for discovery.
Well, it's not just that.
No, but I'm just saying, so that's one, that would alleviate one concern that you have.
Yes.
And then I understand
information to be executed and relieved over to me, which entail all of it. The financials. 12 bonds that have been opened up.
So they can only, so hold on. So they can only provide what they have at their disposal.
Charged.
They can only provide what they have at their disposal. They can't go out, or they're not required to go out and seek information that, let me rephrase that. They don't have to go out and generate discovery. If they don't have it, they don't have it. Does that make sense? So if they don't have a specific bond that you're requesting, they don't necessarily have to go out and get that bond. Do you understand that?
With the paperwork I filed, with the UCC laws on that, it clearly dictates and describes all the evidence that I'm asking for. Now,
and this is where you get to step in as the lawyer. What authority do you have? What case law do you have that says that the UCC applies in a Michigan state criminal charge?
The fact that it's tied to the case.
How?
Because the bonds got opened up through the case number.
But
so
that's attached to where do you get that? Where do you get that from?
Social Security number. You can look it up on Treasury Direct.
But that's not my responsibility.
No, it's not.
So
in due diligence and learning, we started looking. Multiple friends are helping. So they're pointing us in the right direction. So we have literally seen it. We have photographed it. Over 12 bonds have been opened up with a numerical value over $500,000. As of right now, over $500,000 in EE bonds and I bonds have been opened up off of this case. The only thing attached to this case is my social security number, which my estate owns.
So who opened the bonds?
Well, I would have to be given time to file the paperwork, which I've already been filing. I've already filed with the Trade Commission on the fraud that I did not authorize these, and I want to see the wet ink signatures. I also filed for the fiduciary change with the Treasury Secretary. The ID will be coming back. That was wonderful because there's a few documents that I have to scan my ID for before I can submit them to the state to continue moving through for my nationality status in whole.
And who do you apply to for your nationality status in whole? Because you were born
a lot of stuff. A lot of stuff. You got to set the IRS correct. You got to set the Treasury Secretary correct. I got to send a letter to the governor. I got to send a letter to the head sheriffs. And like when we lived in Alabama, it was a sheriff's director board or whatever. They had a meeting every week.
For those who didn't quite catch that, he's talking about having to defend himself against people who have various ideas about him. What he's actually referring to is the fact that he's a convicted sex offender who is required to register in every state he moves.
I'd have to send a letter of notification of the revocation of the driver's license and driving privately. And already switching over the titles to the trust, just running low on equity, which is why the other reason her case is tied to mine. Misconduct. They removed her as the victim. She can't use her legs properly, and she's doing the best she can. We would both be working. I had to stop working because my foreman found out about my CSC, and he tried to squish me with 6,000 pounds of steel that I just got done welding up. That was the second job. That was DCL, Traverse City. Before that, it was Stage Right out of Clare. They loved me so much, they didn't want me going to third. They offered me first after I got out of the temp service, because I got into the temp service because I have documentation from the SOARS department stating you don't have to register because you are not a Michigan resident. We support jurisdiction and constitution. But once you sell your house and you're no longer domiciled in Adams County, Illinois, you have to get a Michigan license. So I registered in the private and have registered in the private of my own free will and volition to prove I am not a threat to a community. That if there ever is a problem, you can call me up, because the only ones that can see me are y'all.
What do you mean by that?
When we moved down to Illinois, they sent a letter. They never would have prosecuted me. They never would have charged me. Here's a letter stating that as long as you're an Illinois resident, you will never have to register another day in your life. Wow. I was able to hold the job for 13 years. Didn't get pushed off, didn't get hit, didn't have people trying to kill me. That's why we left Michigan. And it went to our children in public school. They were tormented, tortured. But I have documentation proving all the way from Ottawa County, Ottawa, Granville, Grand Rapids, Mecosta, stating I didn't have to register. And I am doing it of my own free volition to protect those that might think.
You're not saying you're okay with that. What you're saying is you'll get the chance to raise those issues later. Just not right now, a couple of court dates down the road. The defendant objects and the judge notes the objection, allowing him to represent himself while the public defender remains as standby counsel, and the matter is reset for a probable cause conference. The judge then addresses a motion to set aside a default, noting there is no default judgment entered. while the defendant says they received something in the mail and didn't understand what was going on. It's clarified there is a civil infraction for failure to pay a booking fee, and the defendant explains he and his wife were told by an officer the $12 fee could be paid at a kiosk 24/7, which they did and have a receipt for, but later still received notice of money owed, which he says doesn't make sense. The judge ultimately sets aside the default so the issue can be handled in the normal course of business and instructs the defendant to check in at the front window for the next court date.